going on? How's everyone doing?
Shout out to Colin. Everybody else who's cool with Colin.
Chucky, I didn't say.
Get your popcorn and your Coca-Cola and relax.
Anyway, tell Colin I'm ready.
What's going on? This is Colin. How's everybody doing? Happy Friday. Hope you guys all had a great week. Wait, it is Friday. Yeah, it's Friday. Yeah, Friday. All right. Let's see. What do I got tonight? I've got Judge Simpson, a long Judge Simpson here, and it's about 35, 40 minutes long. It's long. It's a long one, but it's a good one. I promise it's a good one. Who we got? Let's see. I see Legal Fiction, Allie, Skiz Rock. What's up, everybody? Hope you guys are all having a great night. All right, you guys ready to watch some court? Let's watch some court. Let's watch some court. Before I hit that play button, you know what to do. Hit the like, subscribe, do your jump kick backflips. Let's go. Before we get started. I was going to say, is MB here? I was going to say, if you see MB, let me know. Yep. There we go. MB, thank you so much. You sent a very generous PayPal this afternoon. Thank you so much for that. That is awesome. I appreciate it more than you know. Thank you so much. And I'm glad you're here. And yeah, let's go.
Court calls the case, people, state of Michigan versus Michael Kyle.
Assistant Prosecuting Attorney Morgan Barroso on behalf of the people.
And Matthew Mansour, Assistant Public Defender, with and on behalf of Mr. Kyle, who appears to my left. Mr. Kyle, can you state your name for the record, please?
Michael Kyle. All right, he can have a seat because.
Okay, thank you, Your Honor.
All right. May go ahead, Ms. Barroso.
Your Honor, I primarily am going to be relying on the motion. I do just want to note, after having received and reviewed the defense's response, there seems to be two focuses there. One, that Mr. Kyle did not engage in any actual wrongdoing, and two, that any potential wrongdoing that may or may not have happened did not actually lead to the victim failing to appear. There was one statement in the first call where the grandmother had patched in the victim, where she said specifically, I know, and I still don't think there's a reason to put your hands on somebody though. And Mr. Kyle responds back, I didn't put my hands on you like that. And if I did, I apologize. To me, this is really the heart of the issue, is that he is persistent.
Hector Cam Clips. I always want to call you Hector Court Clips for some reason, but I saw your Discord messages. I'm not ignoring you. I haven't been on Discord much today, so I did see the notifications when I jumped on, and I promise I'll check them after the stream. But I'm not ignoring you, bud.
And consistent in telling her that she needs to call and tell them that nothing happened and that he didn't choke her. And this is the statement where she says, no matter what, that's not a reason to put your hands on somebody. And he says, I didn't. And if I did, I'm sorry. That's the heart of this. And if we're talking about wrongdoing, the content of this call is a continuation of the wrongdoing that we see in the initial incident, where he takes the phone from the victim and keeps her from calling 911 to call his grandmother, where she tells him not to call. She tells the victim not to call 911. This is a pattern of behavior that we're seeing continue on after his arrest and arraignment.
But isn't there even a more concrete statement where there's an indication where the defendant is talking to the grandmother about communicating to the victim to change her story?
Correct. And I think that goes beyond the direct contact between the defendant and the victim, and it relates to ongoing contact that has continued outside of the jail between the defendant's family and the victim. She is so in fear that she did not appear for preliminary exam, and I'm concerned that she won't appear again which is why we filed this motion, because of the defendant's persistence and pattern of behavior exhibited in the initial incident and then continuing in the calls.
Thank you. Thank you.
Thank you, Your Honor, and thank you for allowing us to have this hearing. My objective today is to show this court that the people cannot establish their burden even by a preponderance of the evidence. Just to clarify what the people have just mentioned on the statement that was just said about regarding putting their hands on someone. Your Honor, we're here for a forfeiture of wrongdoing motion. And if we finish that, the context of that statement, he also said, I did not, and if I did. So I just wanted to put that before I forget. I believe all three elements are in our favor, and I will use the standards set forth in.
Even if done through a third party?
Your Honor, I will address that.
No, you will address what I ask you to address, even if through a third party?
Even if through a third party, the elements?
If there's a statement made by the defendant to a relative, I believe a grandmother.
Yeah, the defendant's sitting down right now. So if the defendant's sitting down, he's probably allowed to sit down behind him. So, I mean, the action of standing up and trying to jump forward, that would be enough time for just the bailiff to just grab him, I would assume. So, yeah, and this isn't a short hearing, so. But you might be right. I don't know.
In this case, or his mother, indicating between the two of them to tell the victim to change her story. And then an acknowledgement that somebody will. Why isn't that a wrongdoing?
Your Honor, that will go towards the clarity, the intent, and the purpose behind why to change her statement. And I was going to go through this element by element, and that question, the best response to that question is, if you go through the jail calls, which I'm sure you have, if you go through the jail calls, I'll just go through them now. In the jail call on March 26, 2024, in the motions at 8:25:55, Mr. Kyle called his grandmother, all right, and Miss Lazarski. And if you look at the jail call at 3:05 into the jail call, so did you tell them I choked you? This is a question towards the complaining witness. Miss Lazarski stated, I didn't say anything to them. Okay, at this point, there's confusion. There's mixed testimony that we are trying to clear up. Mr. Kyle then followed, can you call up there and change your statement? Can you call up there and change your statement because they are saying that. They are saying that. Then she responds, I'll call them and talk to them. So her intent is clear. Okay, and then grandma responds, they hear everything on this phone. So they are, and when you make phone calls from jail, we all know it says this is a recorded line. Mr. Kyle responds that it's not about them. They told me, you said that I choked you. They're telling me that you're saying I choked you. She responds again, I'll call up there and talk to them. Mr. Kyle says, is that what you're trying to do? Question. Or do you just want me to leave you alone? Question. I get out, is that what it is? 4 questions. Answer to that question is, Your Honor, he's not calling his grandma to say, oh, fix her statement because she her statement is concrete, because what Miss Lazarski is telling him is she's saying this never happened. I never told them any of this. So, and I highlighted in another call. On March 26th, the day before the arraignment, at 18:39:58, at 9 minutes and 47 seconds into that call, Mr. Kyle asks her, "You said you had said what?" And Miss Lazarski replied, that it's not how it went, and that I wasn't, and I didn't say any of that, and that I didn't want to press charges or move forward. Mr. Kyle replied, and I love that. Mr. Kyle replied, "I mean, if that's how you feel, then of course go along with it. But you know, when I talk to you, here we go, it's completely different from what they are saying." So that is my response to that.
Why wouldn't that manifest an intent of some type? I mean, if what you're indicating to me is I'm supposed to garner some intent, that it has to be something direct. I mean, why is he involved at all in the changing of what allegedly is said? Why is he doing that at all?
That's a great question, Your Honor.
It is.
And thank you for bringing that up. And the response to that would be, Mr. Kyle is facing potential felony charges. He's not been arraigned yet. He wants
Chris, good to see you. Hope you're having a great Friday.
to know exactly what's going on with what the police report saying, what the complaining witness is saying. Again, the no contact is not set in place. So Mr. Kyle's liberty is at stake. So I don't see it to be unreasonable for a situation like what Mr. Kyle and the complaining witness have gone through allegedly, for Mr. Kyle to call immediately on the mother of his child, the complaining witness.
What have you missed so far? Not a ton. The attorney is grasping at straws, trying to defend his client from essentially intimidating the victim. That's what's going on here. So that's what the case is about, or this hearing's about.
To clarify what is going on.
But he goes beyond just what is going on, doesn't he?
I respectfully disagree, Your Honor. I don't think it goes beyond what is going on.
If he calls her and says, "Well, what's going on? This is what I hear. This is what you hear." Okay. But he does more than that, doesn't he?
Your Honor, if I may.
Yes, go
He
ahead.
goes beyond asking for clarification. He makes explicit statements. He says to his grandmother, "Can you call her? I need her to change her statement." That's not a, can you ask her what happened? Can you ask her how she felt? Can you tell me what is going on? He says, "Can you call her though and tell her I'm on the phone so she can change my statement and I don't have to go through with felonies? Because I'm not even gonna get out of jail until tomorrow." That's not a, "Can you tell me more?" or "What's going on? I'm confused." That is explicit and direct and with intention. And it is exceedingly clear that this is a manipulation of the victim.
If that's how you feel, then go along with it. You are telling me you did not say any of that. So this isn't a, oh, well, go up to, let me call grandma and tell her to fix the statement. Fix your statement in regards to the truth is what's going on. If you are telling me you did not say that, but the police are saying you said that, then just tell the truth.
Counsel, but your argument, the court would never, well, would rarely be able to find that there's any intent to do anything other than try to clarify. I mean, because I mean, it seems to me the argument you're making is that it can't be the context or the sort of totality of all that's being said into maybe said to various parties regarding this to express some intent of the defendant regarding this particular case. But that as I hear your argument, it almost has to be some express statement on his part.
Your Honor,
The court to find that there's intent.
Your Honor, I believe, if I may, I'm sorry.
Go ahead.
I believe there needs to be, and I've sat in on a motion, forfeiture motion hearing in this honorable court just last week, and I loved the court's analysis because it took the context of the call, of that jail call, and obviously this is completely different facts, different circumstances, but the court in its analysis almost made a spectrum of the context of the jail calls. It was the spectrum almost being don't show up, and if so, lie. And this was another case, not has to do with this. This case here that we're here for, I believe, is almost opposite of that. And that don't show up and lie is egregious. It's undue influence, it's manipulation, it's obstruction, it's pressure.
But what would be the ramifications if she doesn't change her story?
Your Honor, that's something for the court.
No. I'm saying as between the two of them, what would be the ramifications of her not changing her story?
Well, Your Honor, technically she did change her story. She called up here.
Okay.
So if we're going by the police report, correct. The ramifications of her not changing her story is detrimental.
I'm so sorry to hear that. Sue, that's awful. I'm really sorry. I don't really have words to say right now to that. I'm not good when it comes to that topic. So, but I am truly sorry to hear that.
Detrimental. But but if we're going off of her statement after this alleged,
Counsel, what I hear you saying is that, and all of these are very different in terms of what is said, is that somehow or another it has to be so direct that there can't be sort of this manifest, one couldn't conclude that there's some intent to not have this person testify or to have them even testify falsely.
Your Honor, I believe it's the intent for the complaining witness not to testify, or if to testify falsely, or make the complaining witness unavailable whatsoever to the court. Ms. Lazarski, the complaining witness, I don't know how much clearer she could make it, she could state it in the jail calls. I don't. I
mean, what he wants is he wants it to go away. He doesn't want to face the felony charges. He says that, right?
And that's,
well, no, that's what he says, right?
Of course, yes.
And then says in essence, you need to change your story so that doesn't happen, right?
I don't know.
Well, what do you know? I mean, what do you mean you don't know?
No, I'm not saying I don't. I don't agree with that, Your Honor.
What do you think he's saying then?
What I'm saying is he is trying to have her testify to the truth. If she is telling, Your Honor, if somebody's telling me
Yeah.
something,
Then why even bring up the felony charges?
because he's facing felonies, Your Honor.
But he says, I don't want to face the felony charge. I don't want to be here on a felony. Why do you think he says that?
Your Honor, that's what I'm sure many people would say.
Why do you think this defendant said that in the context of what else he was saying?
Because he's saying this because she is telling him that is not what went down. That is not what is said. So why are they saying, why does the police report say that it does say this? Because now I'm facing felony charges.
Is that really what you think he said?
Your Honor, if I may, it's not just I want these felony charges to go away. It's beyond that. It's if they don't go away, I'm gonna be here for a really long time. I'm not gonna be able to talk to you or our kid. I'm not gonna be able to be around. It's holding over not just the bad, but also the good. But then you have in the back of the victim's mind, the fact that she just got strangled. And so you're dangling a carrot and the potential of the negative as well. And he's very explicit about the potential consequences. I'm looking at felonies. If you don't change your story, you want me to leave you alone, or they probably won't find out. Like,
Yeah, so he's pretty much already pled guilty to contacting through a third party, right? There's no denying that. But he's trying to say he's not, or his attorney is trying to say he didn't intimidate her. So he shouldn't be violated for intimidating a witness when he didn't intimidate her. That's what the whole argument's about. Also, while I'm paused, this isn't Judge Simpson's normal courtroom. I don't know if he said why he was in a different courtroom at the beginning of this, but he's in a different courtroom for some reason. And if you notice, the prosecutor and the defense table are swapped. No idea why that is. That doesn't make any sense to me. I mean, they're just tables, right? Why would they be swapped? I don't know. All right, let's go. Oh, you know what it is. The jail, I just figured it out. The door to the jail is on that side, is on the right side of this courtroom, which is why they're swapped. They won't allow the defendants to walk by the prosecutor's table. Okay, that makes sense. I just answered my own question. See? Thinking out loud. Let's go. No. What's up, buddy?
I'm gonna have to stay in here until my court date. It could be weeks, months, however long. And if we're talking about him wanting to get to the truth, when she says explicitly, I still don't think there's a reason to put your hands on somebody, that is a candid statement that she made. And he discounts that. He immediately says no. She tells him the truth. He makes an unsolicited, excited utterance that he put his hands on her, and he immediately brushes that aside because it's not what he wanted to hear in that moment. It's not what he wanted to have said on the recorded line. And when he's faced with the truth, he goes right back down the line of dangling the carrot. If you change your story, I'm going to get out soon, not in weeks, months, however long. Can you please do that and let them know that I never put my hands on you?
Mr. Mansour,
Yes, Your Honor.
you talked about this spectrum that the court had brought up in the other.
Yes.
Why are you saying this one falls closer to the other?
Hey, welcome, Nikki. I'm glad you're here. And thank you. I appreciate that. I don't feel much chipper than I did yesterday, much more chipper, but I appreciate the comment.
Other end.
Your Honor, I'm saying that because he's not, to my knowledge, he has not said one time, don't show up to court. Okay. Then.
But it doesn't always come through that way.
Okay, that's correct, Your Honor. That's correct. Also, he's telling her to testify to what the truth is. Your Honor,
He's telling her to change her story and say that. Right?
Your Honor, she is saying that that is not how it went, and that I wasn't. And quote unquote, this is her saying this. I didn't say any of that.
What do you expect her to say?
The truth to a police officer?
No, to him. What do you expect her to say?
Your Honor, this is the same complaining witness who is putting money on his phone to tell him, call me. This is the same complaining witness saying, I love you, back and forth. This is the same complaining witness that he shares a child with. I don't want any of this. These statements are vital to show exactly why she called the police to say she wants the charges dropped, why she didn't show up to the preliminary exam, and why she will not show up on the 21st. Because I don't want any of this. That's all I'm trying to show the court is this is as clear as this is her own words. And it's in the jail.
That I don't want any of this. And so none of that you're indicating to the court is prompted by the defendant's contact with her, the defendant's insistence to his mother or to the grandma that you need to contact her to change her story. None of that has any bearing on her whatsoever, Mr. Rinser?
How can we say it does against him?
How can you say it doesn't? I mean, if and I realize that it's by preponderance of the evidence, but what I've got is I've got someone who makes a statement about putting your hands on someone, right? Then all of a sudden, I confront you with what they say you said. She basically is saying she doesn't want any of this. Well, that would be true for a lot of domestic violence victims, that they don't want any of it. They probably don't want a whole lot of things.
And that I didn't say any of it too, Your Honor.
Right. What's she supposed to say, Mr. Mansour? Why? See, this is part of the problem here, is your client should have been contacted you in the first place. Shouldn't have been contacted you in the first place and shouldn't have been trying to contact through third parties to then tell third parties to tell her something. And now.
No, I completely agree. Is there a defense to this? Yeah. I mean, it's barely one, but yeah, you can have a defense to this. This is just kind of it's pretty clear that the attorney didn't actually prepare himself to be questioned by Judge Simpson. Every time Judge Simpson asks him a question, yeah, he doesn't have an answer for it. He didn't prepare himself to defend his point. He only prepared himself, the 30-second defense that he has. He didn't say change your story. He said, if that's what your story is, tell the truth. If it's not, change it. That, I guess it's still a stretch of a defense. You shouldn't even be talking to her. Just saying.
When confronted with it, and he's smart enough to realize, I'm not going to say those things like don't show up, don't whatever. That's why the court has to listen to the context of everything that's going on that the court has to determine whether or not there's some intent on this defendant to stop this victim from testifying. So while you might draw that one conclusion, isn't it equally plausible that the opposite conclusion has to be drawn?
Of course, absolutely. Absolutely, Your Honor. But I'm trying to persuade or show this court that it's not, and if we look at People versus Burns, if we look at the fact pattern there, the facts in that fact pattern, the defendant tells the complaining witness not to tell.
Yeah, I thought that was just on my end. I have no idea what just happened. It just got really loud, didn't it? I don't know why. I don't know if that's on my side, but the video just went from, normal volume to really loud for some reason.
Don't tell anyone or she will get in trouble. And the court in that case ruled that there was no specific intent for the complaining witness to not be or to be unavailable for court. They were correct on element one. Was it wrongdoing? Yeah, not to tell. Don't tell anyone or she will get in trouble. Yes, that's wrong. But they ruled elements 2 and 3, specific intent to not show. It's a case-by-case basis, and it improperly assumes the defendant's knowledge.
That they not show?
Had the defendant intended to have the complaining witness not show.
But your whole argument on those points rest on the exact verbiage outside of context and outside of what may be the reality of what's going on. Does it not?
Yes, it's case-by-case basis, it's different facts, different things said, different circumstances. Absolutely. I want to point to the court that,
why would he need her to change her story?
Because if the police report,
why not just go up and say, okay, if that's not it, then you need to go to the hearing and you need to tell everybody that. Why not just say that?
well, Your Honor, this is a fresh matter. He made the calls before his arraignment, wanted to speak with his.
Why the pressure on her, since you don't want to answer that question, why the pressure on her to, through grandma, pressure her to change her story? If I've had a conversation with you regarding you didn't do this, you didn't say this, you didn't do whatever, why am I using a third party to also reinforce that?
I don't know what his phone minutes situation was at the time. I'm not.
What's that mean?
I don't know if he could reach her and check the status on whether she did it or not. I don't know if she has transportation. I don't know if she has he probably doesn't know if she.
That's not my.
That was probably the worst defense you could have had for that question. Come on, man. This is why I said in the thumbnail that this attorney needs to step his game up a little bit. He struggles when being asked questions. It makes me actually think that this defense attorney, I don't think he believes his client. I don't think he believes, the bullshit that he's spewing right now. He can't defend it, but he's trying. He is trying. But yeah, I do feel that he's a little green. Okay, while we're paused, Julie, thank you so much for the 5 gifted memberships. Thank you so much, Julie. Very generous of you. And welcome to all the 5 new members. Members only Monday. What is that? 3 days away? Almost there. And Flynn. Hello, Colin. I'm here, always lurking. Thank you so much, and I appreciate the super chat. Very generous of you. All right, thank you both. Let's go.
Question. My question is, why does he use a third party to also try to exude, at least as the court sees it, that pressure for her to change her story? If, as you portray it, they're having this wonderful conversation and she's saying, no, basically, I didn't say all of that. They've all got it wrong. They've got it this. And that they come to some miracle understanding that she should then contact them to change her story. Why tell a third person they need to to basically reinforce that to her? Why do that?
Thank you, Your Honor. Because Mr. Kyle is sitting in jail and has no idea what's going on. And he would like to check the status on whether the statement has been corrected to
Why
its
didn't
truth.
we just ask her?
Did, Your Honor.
But so you're not answering my question. Why do I use a third party to do that if I've had this meeting of the minds that you got it wrong to the police, and so therefore now you're going to make everything better by changing your story? If that's the case, why have somebody else have to reinforce that? If it's, you just need to tell the truth, why do I have to have somebody else call and say?
Yeah, Your Honor, it's a great question, and I will answer.
I'd like a great answer.
And my answer is to check these stats.
My answer is I've got nothing. I've got nothing. Thank you, Your Honor, for asking that amazing question that shows that you understand this case better than I would hope you would. You did? You would? I don't know. Yeah, the judge isn't buying the story. We got some more gifted memberships coming through. Legal Fiction, thank you so much. 10 gifted memberships. You're awesome, Legal Fiction. So generous of you. Sparkle Poots with the 5 gifted memberships. Thanks to you, Sparkle. And Kathy Berry. Kathy, thank you so much. 5 more gifted memberships. 20 total gifted memberships in the last 5 minutes. You guys are awesome. Thank you so much, Legal Fiction, Sparkle Poots, and Kathy Berry. And welcome to the 20 new members. All right, let's go.
Status on whether she did or not. And mind,
But he didn't ask the person, check on whether or not she did.
Your Honor, I believe in one of the jail calls. Did you talk to Rachel? Did she manage to go up there along? I'm paraphrasing this, but
She needs to change her story. Operative words.
not because it's
You need to tell her to change her story, basically.
because if she does not,
Is that really checking on status, counsel?
Your Honor, also,
Is that really checking on status?
I can't tell you exactly why.
That's your argument. Your argument to me is that he's checking on the status. Is that checking on the status to you?
It can be, Your Honor, if he's
Seriously? That's checking on status?
did you talk to Rachel?
Go ahead with the rest of your argument.
Your Honor, in regards to that as well,
Just look at him. Judge Simpson. Yeah, like I'm not buying this. Just go ahead. Just go ahead and finish your argument. It's kind of like me when I want a video to end and just keep getting interrupted with super chats. So I keep pausing it. This is what I'm like. Oh, guys, you guys are awesome. But I really want this video to finish. Not the same thing at all. I love all of you. All right. I was gonna say something. Oh yeah, tonight's bonus clip. Do you want? I'm gonna put a poll up, but I'm gonna tease it a little bit. There's 2 options. We can watch Judge Van. I can just play part of Judge Van's docket, or I can play Judge Simpson yelling at a during a landlord-tenant case. I'll put the poll up in a few minutes, but those are the options. So think about them.
his grandma, his mother, all are in communications with Rachel. They in regards to their child, they've said it many times in the jail calls. We're calling to check up on the child, And there was statements in a lot of those jail calls where the mother herself, this is between you guys. All I care about is the baby. So, I mean, I'm sorry, I can't give you a pinpoint answer on why he called the grandma to see the status, or to ask if she's talked to Rachel, but those are the circumstances.
Anything else?
Your Honor, I just want to harp on the fact that the language, the demeanor, and the motive behind those jail calls, or in context of those jail calls, was not to procure unavailability. Because not once did he say, don't show up. Not once did he say, lie. Okay, the motive was to correctly testify. So I don't believe any of these elements are met. None of the three, due to those reasons. You know, if he was telling her, hey, you got to go up there and tell him I didn't do any of that. Tell him make something up, lie, don't show up. No, the jail calls. What did you say when you got up there? That I didn't do anything. Okay.
So you really think it has to be that direct?
It's by a preponderance of the evidence.
No, but do you think the examples that you give are certainly the most egregious of circumstances? My question to you is, are you indicating to the court that it always has to be that direct, that there can't be context to what's being said?
Your Honor, that is exactly what I'm saying. In our favor, though, the context of those statements. Does it have to be that direct? No, it could be many different ways. You know, we look at People versus Jones. People versus Jones, in that case, there was the facts were the defendant was involved in a gang, and the complaining witness didn't testify because of the repercussions of testifying in a gang. Or People versus Giles, where the defendant made the complaining witness unavailable. The complaining witness she's available. She's available. She just does not want to proceed. She does not want to move forward. She said it. And so, no, it's not that direct. There's context to it. It's case by case basis. And if you look at everything that is going on, I don't know. I don't know where he said don't show up. I don't know where he said don't lie.
Hang on, counsel. That's precisely what I'm asking you. You keep coming back to that. And I'm asking, does it have to be that direct? You tell me it doesn't have to be, and then you proceed to argue that. So I'm unclear where you're coming from. Well, my question to you is, there are ways of telling people not to show up or placing them in a difficult position where they don't, which would be tantamount to saying don't show up. By way of example, if the court draws the conclusion that he's asking her to change the story, that she then tries to change the story, but it doesn't change the posture of the people in proceeding, she's now caught. Because now she has to show up and lie or just not show up at all. And you don't think that one, through that series of events, could reasonably draw that that's what the defendant's intent was? That if it works, it's gone. I'm out. But if it doesn't work and they don't get rid of it, then you gotta lie or you gotta do whatever. I placed you into an impossible circumstance. Why wouldn't that be tantamount to causing the unavailability of the complainant and have reasonably been what he desired to occur?
Your Honor, could it not be her own choice to not show up? Could it not be the fact that she does not want to proceed on this? And it could also be due to the fact that what was said was out of context. There was no indication of,
If her choice is a voluntary one, then maybe. The problem that you have is you've got all of this, which would lead the court to the conclusion that if she doesn't show, that's not voluntary on her part.
Your Honor, the court here has revoked Mr. Kyle's phone privileges.
Because he violated bond.
That's, yes. We're not objecting to that, Your Honor.
Well, you can object all you want. He violated bond.
You're 100% right.
I know. So
Okay.
what's the point of this?
Your Honor, his phone privileges were revoked on the 6th of April. The preliminary exam was on the 21st. She has had all that time, almost 2 weeks, with no contact, nobody's spoken to her, to make the decision.
Oh, no. That's not true.
You're right.
I know that's absolutely untrue. His contact comes through a third party.
Ooh, that pause, and yeah, he just said the Judge Simpson just said that's not true, and the defense attorney, I know. Why would you say it? Why would you say it? Karen, thank you so much. Member for 4 months. That's awesome, Karen. Thank you so much. I appreciate it. You are awesome, and thank you for supporting the channel. All right, let's go.
Your Honor, I misspoke on that. I meant to say Mr. Kyle did not make any phone calls, obviously, because his phone privileges were revoked. However, Your Honor, I've said all I've needed to say in purposes of this argument, and I appreciate you taking the time and this court to allow me to make those arguments.
Thank you. Anything else from the people?
Nothing further.
Court in reviewing that and listen to the phone calls and giving context to those phone calls. The standard here being a preponderance of the evidence. The court is of the opinion that the context made to, let me say that, it would be, I guess, easier if defendants were just saying to victims, alleged victims, don't show up, don't testify, don't do that. If they use those exact words, these become simple analysis. So that would be easy. Or, if quite frankly, defendants would abide by the bond condition of no contact, then that would be easy, because then if they don't show up, it has nothing to do with, or would not possibly have anything to do with what the defendant did. But none of these or very few of them, I should say, are that direct. They go through other mechanisms by which to have the victims either not appear or change their story or in some way attempt to try to cause their unavailability. Clearly, his contact and the statements made are wrongdoing on his part. The court believes by preponderance of the evidence that the statements made, the context upon which they're made, the further contact with the grandmother directed to say things or continue to say things to reinforce things to this alleged victim. The court does believe that by preponderance of the evidence that was specifically intended to procure either her false testimony or her unavailability, should that not, or could she not stomach making the false, what may be considered false claims or changed claims. The question as to whether or not is engaging in that wrongdoing, and then whether or not it has caused, will cause the unavailability of this victim. It already has on one instance, and or caused her to take a course that it did. It may indeed on the May 21st cause that to happen. It certainly did on April 23rd. This court's belief is, having listened to everything. And so for those reasons, the court would grant the people's motion, and that the statements, if they are otherwise admissible under the Michigan court rules regarding evidence of the alleged acts of domestic violence, will be admitted through the proper witness, that typically being a police officer. So people's motion is granted. Thank you.
Thank you.
Were they able to clarify anything regarding Gates?
I don't have any.
All right, I kept this in just because, Judge Simpson just went through that. This is only about a 1-minute conversation with the attorneys, but it shows how quick he can flip his mind and think about something else. So yeah, nothing real interesting here, but it's kind of humorous.
Yeah, that's her. Are they? Okay. People's motion is granted. His exam is the
21st.
You guys are seriously voting for I Like Turtles? I mean, yeah, now I gotta go find a turtle clip real quick. That was just in there to be a joke.
Yeah, don't bring him out.
But it's winning. I Like Turtles is winning.
Gaines
Yes.
on Gates, is it?
Yes.
Do we have any news on Gates?
Yes, sir. Miss Brown is also here. Would you like for us?
Why is she here?
Because Miss Hightower Brown is in.
Why You throwing her under the bus?
No,
Is
I'm
that
not
what you're
throwing her
doing?
under.
No, that'd be fine with me.
No.
No, that'd be fine with me because I want to drive. If you gonna throw under, I want to drive. You can,
I'm letting you know that
like,
she is
beep,
on
beep,
it.
and then just back up and then just what?
She is on top of it. She is in the process of appointing someone.
Oh,
And I can-
oh.
If-
Councilman Ms. Brown
Could approach.
approach, please. And geez, oh Pete, can we go? Yeah, put the white noise back.
All right, that is it. All right. Next, we jump to Judge Washington. I do have two short clips. I got a Judge Washington and Judge Taylor clip. Yeah, that one was kind of hard to listen to. Just the defense attorney was struggling with no defense. Like, I mean, I'm not going to say no defense. He had a small defense. And yeah, I guess technically he didn't say, go change your story. But the fact that, he called his grandma and said, can you check to make sure she changed her story? That's very bad. That's very bad. Just saying. That defense attorney, he was not ready. I'm gonna guess, but yeah, he was not. He did not do his client any favors during that hearing. All right, Judge Washington, let's go.
You're welcome. Have a good day, Ms. Overson.
You too.
Oh, you want me to wait? Okay.
Pay very close attention. So when the defendant starts talking, in probably like 2 or 3 minutes, pay very close attention to her facial expressions. Because every time he talks, like you can see her face move, and she wants to laugh and smile at this guy. It's like, what are you saying, man? Like, not good.
State of Michigan versus Taja Rockingham, case number 23FB 1027.
Stop.
Okay,
McDuffie for the people.
please wait.
Yes.
There's a huge stop, means we can't record, so.
Assistant Public Defender Sandra White. Oh, I'm sorry. I'm sorry. We're back on your honor.
Thank you. All right, you may proceed. Ms. McDuffie, please start with your appearance, please.
Rachel McDuffie for the people. Assistant Public Defender Sandra White on behalf of Tajay Rockingham.
Ms. Rockingham, please state your name again.
Jay Rockingham.
Oh, that's a guy. I'm so sorry, Mr. Rockingham. All right.
Jay Rockingham.
Thank you, sir. We're supposed to be here for sentencing today. I don't have a PSI. Do you guys have a PSI?
It's a no-show report, Your Honor.
Okay, thank you. So what does the report say?
Failed to appear for PSI appointment, $60 referral fee. The appointment was on April 23rd at 3 p.m.
I didn't ever get that.
Mr. Rockingham, it would have been sent to you via email, sir.
Yeah, I didn't get it there either.
Mr. Rockingham, you do understand now that if you don't, you need to contact probation and make sure that you get your next appointment, correct?
Yeah.
Okay.
Ms. Johnson, are you present? Your case.
I am, Your Honor.
Thank you. Hello again. This is Mr. Tajay Rockingham. He's claiming he did not get a copy of the appointment notice.
So it looks like that Ms. Wallace scheduled his appointment and sent him information in regards to that back on April 3rd when she spoke with him, which was scheduled for April 23rd for myself.
Oh, she spoke with him personally?
No.
I can verify with her if she did speak with him, but I have the paperwork from her that she scheduled the interview with him.
When you say you have it, was it sent via email to him with you CC'd or what?
She sends him an email as well as mails him out a copy of the notice for the appointment.
All right, thank you. The sentencing in this case will be adjourned to June 27th, 2024. at 10:00 a.m. And there's a $60 re-referral fee. Sir, this is the last opportunity to get this done.
I'm not understanding what's going on because I never talked to anybody about anything. I'm fighting 2 other cases, so I don't understand. Like, how would I have to pay for something that they did wrong? Nobody contacted me about nothing.
All right. The sentencing in this case is going to be at 11 a.m. and it's going to be in person. We can talk about that when you get here, sir. Okay? Mr. Rockingham, as I told you last time, you need to reach out to the probation department by after 9 o'clock tomorrow to schedule that appointment.
Ooh, trying to get a pause in between Judge Washington, Judge Washington and Miss McDuffie is difficult to do. Jelly beans. Thank you so much, Simpson and Van. Possibly, maybe this is not abroad. Yeah, I mean, we'll see. We'll see how the night goes. I mean, it's Friday. Court's slow on Saturdays, so maybe we'll get both. Maybe we'll get both. I don't have a video release for the Judge Van docket though, so it's about a 30-minute video. It's literally just his docket, so I would just be playing a portion of that. But we might do both. I appreciate the super chat though, Jelly Beans.
I don't even know who the probation officers are, or who they is, or what is going on.
Rockingham. Your attitude today is not working for you. You need to stop.
I don't have any attitude. I just don't know what's going on. And y'all making me pay for stuff that I don't even know what's going on.
Mr. Rock, I'm sorry.
Go ahead, Miss White, because he's
Mr. Rockingham, I suggest that you stop talking. We'll give you a call after the hearing.
You don't have my number? Like, how are y'all gonna give me a call? I don't have y'all number.
Can I get into a breakout room with Mr. Rockingham, please?
Hey, what?
Your Honor, I will state this, that Ms. Walls will not schedule a PSI without talking to the defendant first.
Well, as you just indicated to me, it was mailed to him and it was emailed to him. So that is our standard procedure. Second, Mr. Rockingham, I'm going to give you Mr. Rockingham's responsibility, as every defendant is to contact the probation department. I'm going to give him that phone number one more time before I put him in to the breakout room with his attorney. Mr. Rockingham, do you have a pen?
Yes.
734 483 483 7336
733
36
733
36
7336.
7336.
7333. I got it.
All right, I'm putting you into a White. Ms. White, make sure he has the correct phone number because what he repeated back didn't sound like it was.
Yes, I will. Thank you.
Okay, State of Michigan versus.
All right, yeah, that guy. All right, next one, Judge Taylor, and then I'm gonna start playing this. I'm gonna see what clip won the poll, and yeah, we'll see what we're watching. All right, let's go, Judge Taylor.
Yes, I can, Ms. Taylor. Judge
All right.
Taylor.
Thank you. Now calling the matter of the people versus Maurice Williams. This is ticket SP 1365979. One count, open alcohol and motor vehicle driver. Appearances for the record, starting with counsel, please.
All talking to represent the defendant. Your name, sir?
Maurice Williams, sir.
Your Honor, my client is requesting a waiver trial. You understand his right to a jury trial and wishes to waive that right.
All right. Please raise your right hand, sir. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, you can put your hand down. Did you have a chance to talk to an attorney about your case and about your rights?
Yes, ma'am.
And it's my understanding that you want to have a waiver trial. That's a trial before me as the trier and finder of facts. Is that correct?
Yes, ma'am.
All right. 22-1. I don't know. You've been here a few.
I've been here 10 times.
What about?
Imagine the work I got to do. Oh, he's good. That's fine. Having the file, but, so it's, what you need? Okay. 1535936. Willis. Willis. Thank you. Okay.
Yeah, Judge Taylor.
What about June 6th?
Oh, sorry. Didn't mean to interrupt.
That's 3 weeks from now. I have to give him at least 3 weeks. That work for you, Mr. Williams?
Yes, we still requesting the video camera, right?
You requested it before, Your Honor.
Requested 10 times. 2 years, Your Honor.
Judge, I'm sorry, I didn't hear him. He's requesting what?
A video request.
All right, thank you.
The body cam we're looking for.
Did you ever call the courtroom, Mr. Williams?
Ma'am, I call it all the time. We've been through this 10 times. I'm sorry to say, but it's 2 years, Your Honor. It's not good. 2 years. Same thing.
2 years. Well, I have that you failed to appear back on September 25th of 2023. But then I have that crossed out.
You throwed it out. Then y'all recharged me.
I remember this case now.
It's 2 years, Your Honor. 2 years. Come on. 2 years. I've been 2 years very patient. I ain't been saying, no, I just let y'all just slap me. Just keep on moving. It's 2 years. It's the same old thing. I've been through every attorney. Same thing. 2 years. I've been at pre-trial for 2 years. We got to do better.
Kind of. It's kind of his fault. Judge Taylor's going to explain it real quick. So I don't know what his charge is. I don't know what it is, but the police officer didn't show up, or no, the police officer showed up for his hearing, checked in, and then left. Then it was dismissed. The police officer came back after his hearing was called and said, hey, it was dismissed. Police officer was upset, went to the prosecutor's office and got it refiled. So when this guy didn't show up, when he no-showed, he didn't, he said it was dismissed. So there wasn't a bench warrant out for him or anything. He didn't show up, it was like 2 months later or whatever it was. And he didn't show up because he didn't know. He thought it was dismissed. So it took a while to get in contact with him. So yeah, is it partially his fault? Maybe. But no, I understand his frustration. I do. 2 years. It's already been dismissed. They're bringing it back up on him because apparently he did something that upset the police officer. Yeah. All right, let's go.
I know you're busy, but we got to do better.
Well, first of all, it wasn't me. It was the officer. They wanted it refiled. So if they asked for it to be refiled, I have to refile it, Mr. Williams. So the first time originally what happened, because I'm always transparent. So the first time what happened is that the officer signed into court and we didn't have him down, and then we dismissed it. So he wanted it refiled. And they refiled it. They have that absolute right to refile this matter if they would like to. So that wasn't on it. I do realize as I look at it, so whenever we came back, so that was in September of last year. I don't know what happened in the interim because I don't have any notes. The next time I have that, you appeared to court. So what must have happened is that after we dismissed it, it took a moment for us to get back into contact to let you know that it was refiled. So I didn't put you into warrant status because I didn't think that was fair. I didn't think it was fair because when I told you, are we gonna talk with each other? Or are you gonna let me explain on the record, Mr. Williams? Now, one of the things I do is I really try and work with people. I know it may take a long time, but I try and work with people and I remember stuff. You know how many thousands of cases I've seen over my span of my 13-year career? A ton. And I've had all kinds of criminal cases as well. You keep talking because I got on mute. I was about to say, it's okay. I'm okay with that. Listen, so I remember cases and I remember this case because I remember that it was dismissed originally. And then the officer wanted it to be refiled. And so it took us a moment to reach back out and let you know. So that's why it ended up happening at this point in time. And then we got it back on the docket. I do remember that.
Gotta love this dead air. I'm so good at editing. So good. Yeah, I do too. The last time I was in the 36th district, I really wanted to meet her. I said this before, but she was out on lunch. But I did look into her courtroom, so I got a personal view of her elephant and her flowers. But she wasn't there. Her door was locked. She was on lunch. We do need hold music. With all the theme songs I've been making for people, I need to make some hold music.
All right. I had to ask my clerk because they went to the supervising attorney on this one. So the quickest I can get you is June 6th. That is, I thought I did 3 weeks out. That's the quickest I can get you in here. You want that date?
You talking to me, ma'am?
Yes, Mr. Williams, I'm talking to you.
Yes, ma'am.
Okay. All right. That's exactly. So on that date, you asked for the video. I know you asked for the video before at 9 a.m. Want video.
The video just to show the reason why he stopped me.
Okay. We'll make sure. If not, I'll make a ruling that day. Okay?
Yes, ma'am.
Your Honor, for the record, this is Diachiku Mason, City of Detroit. Who are we sending any discovery to? We need.
So, Attorney Mason, this is let me tell you, let me bring you up to speed on this one. Send it to the court. I'm gonna put in a request for it. Send it to the court because he's right. Originally, you weren't here, so you don't know what happened. But this was a case where it was dismissed. Officer had checked in. They got upset. They went to your supervisor and got this reinstated. And then after it was reinstated, we had to give Mr. Williams some time to let him know that it was being refiled. So he's back here now. So send it to the court. I'll put in a request for the discovery any way I need to.
Okay, just send it to me, Your Honor. Just email the request to me and I will send it on to our person.
All right. I'll request it. That way it'll be here, Mr. Williams, and you'll be able to discuss it with the attorney that day, okay?
Yes, ma'am.
All right. There's nothing further. Bonds continued at $0 personal.
All right. So Turtles technically won the poll. Yeah, I'm going to show you the Judge Simpson clip. And then depending on the interest and how many people are still here, I'll play a little bit of the Judge Van clip. But let's see. All right, here we go. What's going on?
Thank you.
Thank you.
Arbor One versus Tatiana Tedder.
Cheryl Walkup on behalf of the plaintiff.
Yeah, I don't have any videos of turtles. I like putting the third option because that's my sense of humor. I didn't think you guys were going to vote for the turtles. Hey, I don't know. Next time I want to put something that you guys aren't going to vote for. Like I want to see the defense attorney in the first clip of this. I'll find out his name. I want to see him defend another defendant. That's what I'll put that as a third option next time. And then no one's going to vote for it.
Ms. Tedder?
Okay, I'm here.
Okay. All right. Where are we on this case?
Well, Your Honor, my notes
don't know,
indicate
I'm
that
having a
the
hard
defendant
time
was
hearing.
required to file an answer and proof of her claims by May 16th. I did not receive anything. I don't know if the court did.
I'm sorry, I'm having a hard time hearing. Could you repeat what you said?
I indicated that the last hearing, the court had ordered that you file an answer and any supporting evidence to the court and myself by the 16th of May.
Yeah. I can't stop laughing. You guys are awesome. You guys are awesome. I know you want turtles. You know, I'm gonna go try to find a turtle video now. Oh, you guys are awesome. I hate that I love you guys so much, or do I love that I hate you guys so much, or do I just not hate you at all? And I should probably stop saying that. No, you guys are awesome. I appreciate you guys. Thank you for making my night by accepting that the turtles wasn't gonna happen. Let's go. No, Sparkle, no, you lied about the turtle. I didn't. It wasn't in. You know what I did? I didn't lie about the turtles. What I did is I called my grandmother and had her talk to the turtles. And I told my grandmother to tell the turtles to make sure their story was correct. That's what happened. And the turtles didn't correct their story. So, no turtles.
And that I did not receive anything.
Right. So I was unable to get in my emails and find the emails or whatever for the thing. But I went down to the office multiple times to talk to the people in the office, and they tell me you guys will call, and nobody never calls. So I'm just a little confused myself. I've been
ma'am, hold on, ma'am. You told me the last time that your taxes got held up.
Yes, sir.
Okay.
I have not been able to
hold
get
on.
my mailbox
Hold
for-
on. You said it was because of a mailbox situation.
Correct.
And it went someplace else. I told you because you were. I'm not going to try to talk over you.
Okay, sir, you don't have to try to talk over me. I apologize, but this is very frustrating when I've been doing everything I'm supposed to do on my behalf, and they're not doing what they're supposed to do on their behalf. So I'm frustrated too.
Do you guys remember it was a YouTube channel, Birds Aren't Real? Do you remember that whole thing? I'm going to start a channel called Turtles Aren't Real. Just saying. Turtles aren't real. They're not. They're, machines built by the government to spy on us. That's what they are. They're not real. We're going to go with that one. So that's why there's no turtle video, because they're not real.
You told me that the tax check that you had got sent back.
Correct, twice.
I told you because you said that you had the United States Postal Service email on your phone.
Correct.
That you get. And I told you I needed a copy of that email to the court to show that had happened.
Right.
I'm
unable to pull that up on my phone.
I don't have that. What?
And I'm unable to pull it up on my phone, sir. It says my Gmail is out of storage. It only lets me go back so far to my mail because I can't pay for anything because I don't have any money. This is not the only bill I'm held up on. I've been saying stuff for over the last 70, 80 days. And it's like nobody down in the office hears you. But then you want a payment. Like, it's ridiculous.
Ma'am, I heard you when you told me at the last hearing what you said. You told me you had proof of that tax check coming through. I don't even know how much it was. I was gonna give a benefit of the doubt to you because of what was the mailbox issue. That if you showed me that it came, and then go by the rest of your story that you couldn't get to it and it got sent back or held someplace, then I could do something. But I needed proof that had come through. You told me you had the email. I don't have a copy of that.
I am sitting here on bed rest. I can barely even get out the house to do anything. I'm going into labor any day. I don't understand. I'm calling down here saying stuff to them. I can't make a payment if I'm not receiving my mail. And it's like, just forget that I have mail coming in and that my money is in the mailbox. They just want their money, but nobody is doing anything so I can get my mail. This is ridiculous.
Your Honor, the last hearing, my recollection is she indicated she was now getting her mail.
Right, ma'am. I am now getting the mail, but it takes weeks for you to get the mail. They have to send it out, then they send it back. Then I'm waiting for them to send it out again. They sent it out again. They sent it back, and I'm waiting again. Like, I just don't quite understand. But it's okay for you guys to inconvenience me for 70, 80 days. But it's not okay for me to inconvenience you. And it's not even me inconveniencing you if my stuff would have been fixed when I first moved in.
All right, I tried to find a good place to pause while Judge Simpson was still in his like face palm mode. Yeah, don't go after Luckoff. Luckoff is extremely intelligent in what she does. Yeah, and she's not fazed by your argument. You're not winning. You're not winning. Stop yelling. Stop yelling.
Tatter.
Here, when I paid my money
Tatter.
Here, it wouldn't even be this.
Are you done now? Because I'm going to tell you.
Yeah, I am done, sir, but I'm frustrated because I'm steady contacting them and they're not sending
ma'am,
me back.
but you don't overtalk me. I will hear anything anybody has to say. And I listened to you the last time. And what I told you was, you told me that the mail was going back and forth. I said, okay, fine. You specifically indicated there was a tax check that had gone back. I said, fine. Send me a copy from the UPS delivery, from the United States Postal Service delivery message that you get. Send me a copy, and then we could work on timing, because if you couldn't get into your mailbox, you can't get into your mailbox. That's what I asked for, proof that came there, that you couldn't get it based upon your story, and then we could work something out. But I don't have anything. I think I was very clear as to what I wanted.
And I'm unable to get, I said I'm unable to get anything either because I can't even pay for my storage space on my phone so I can even get to my emails. Like, this is really ridiculous. I'm literally about to go on labor any day. I can't just get up and go work. I had everything planned out. If my stuff would have been working from the day I moved in, it wouldn't even be this issue.
Ma'am, I needed proof that the tax check came in and that you didn't get it.
That's actually a good question. And not everybody has a bank account. Not everyone does. When I was in the restaurant industry, there were people that got paper checks because, they didn't have bank accounts. There was one older guy that was kind of, he was afraid of banks, so he kept everything in cash. So that was his reason. But then some people just didn't have them. Mainly, I'll say this, mainly because they didn't have IDs. They didn't have IDs. They were too afraid to go get an ID, and you have to have an ID to get a bank account. So they worked in cash as well. But yeah, they didn't work in cash. They would get paper checks and just, go to a cash checking place to cash their check. But not everyone has a bank account for many different reasons.
Sir, and I don't know how to get you, proof. I've got on my laptop, I've been got on my phone. I'm trying to get it. There's no way for me to get it. I've tried to call them and see maybe if they can send me some type of email stating that they sent it. They said no. So I don't know what else to do. I called DHS. I've called somewhere else to help, which I shouldn't even have to do all this when my stuff came through the mail and I should have had access to it the first time it came.
Ma'am, maybe all of that's true. But I gave you an opportunity to just give me
Prepaid. They'll buy prepaid cards. I mean, that's generally how it worked for the people that I knew that didn't have them. So they would just have like a prepaid debit card, and that's what they used.
proof that the tax check came in, and I have nothing.
Sir, I can't give you something that I'm unable to get myself either. I can't give you proof of something that I'm having trouble with pulling up myself. I have 2 other children here. I don't want to get put out. Like, come on now, this is ridiculous. I paid my money to move in here and I can't even get my mail.
Ma'am, I don't have much of a choice here, though.
Okay, well, you just do what you feel like you have to do. End of story. Like, I'm not about to keep going back and forth with you.
What's the claim, Miss? Hey, I'm done. What's the claim? I've tried. Go ahead. What's the claim in this case?
Your Honor, Brent to retain $2,781, cost $175.10, total redemption figure $2,956.
Court finds no tribal issue. Judgment to the plaintiff for possession. Redemption amount is in the amount requested. Writ to issue 10 days. Court calls the case up.
All right. What are we feeling? I meant to actually. I was too busy talking about the bank account thing. Do we want to watch a little Judge Van? You guys still want to hang out for a little bit, or you guys want to call it tonight? It's been about an hour and a half. So generally, I like to keep it between an hour and 15 minutes. But I'll play some Judge Van if you guys want to. And there's nothing, you know. I didn't edit it. It's just a complete Judge Van docket. I'm not going to play the entire docket through because YouTube doesn't like that. But Lexa wants to hit Discord. I want more VODs. Van, let's keep going. Go. All right. We'll play a little bit of this. I'm not going to play the whole thing. I'll play half. How about this? I'll play half of it tonight, then half of it the next time I do a bonus clip. Yeah, this is 40 minutes long. So yeah, I'm not hanging out for another 40 minutes. Not on YouTube. I turned into a pumpkin. You guys know this. All right, let's go. Let's just run this for a little bit.
Miss Fambro.
Hello.
Have you chose Valence today? No.
Due to
All right.
personal reasons, we will not be doing that today.
What they got going on? Yordani, raise your right hand for me. You solemnly swear affirm you will truthfully and accurately interpret the conversation report in the defense today?
I do.
All right. Ask him to state his name for me.
Dígale su nombre al juez. Alex Noel. Alex
Before the
Noel.
court charged with possession of counterfeit driver license plates.
Bien, está frente al juez acusado de posesión de una placa para un vehículo falsificada,
Failing to register a motor vehicle.
no haber matriculado un vehículo motorizado
And operating a motor vehicle without a valid driver's license.
y operar un vehículo motorizado sin licencia de conducir válida.
I understand he's been given copies of paperwork and advised of his rights. Is that true?
Entiendo que se le dieron copia de los papeles y se le notificaron sus derechos. ¿Es eso cierto?
Yes, no, maybe.
Yes. Sí, no, tal vez.
Based on his application, I find he does qualify. I'm going to go ahead and appoint the public defender representative, so he has an attorney now.
De acuerdo con su solicitud, determino que califica y le asigno
No, this is Florida. This is Bay County, Florida.
al abogado de oficio para que lo represente, así que ahora tiene un abogado.
Deputy, criminal history.
Just no history, no tracking.
Bond set at 2,500 on the counterfeit license plate. 1,000
Bien, la
on
fianza.
the motor vehicle registration. Go ahead, Jordan.
Bien, la fianza son $2,500 por la placa falsificada, $1,000 por no tener la matrícula para un vehículo motorizado
1,500 on the driving license been revoked.
y $1,500 por manejar con la licencia suspendida o revocada.
This court date will be June 3rd at 9 o'clock.
La audiencia va a ser el 3 de junio a las 9 en punto.
Buena suerte.
Open. Next.
Come on in.
Thank you, Your Honor. May I be
State,
Yes, sir.
Thank you, Your Honor.
state your name.
Alan Joseph Majerus.
Mr. Majerus, before the court charge driving under the influence. You understand that charge?
I do, Your Honor.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, Your Honor.
All right. We have an attorney, Mr. Majerus.
Yes, Your Honor, I'm here on behalf of Mr. Majerus, Elizabeth Peskin.
Elizabeth, I can barely see you. They get you so small that I can't even tell who's on the screen with us.
My hair is back too, so it
okay.
doesn't really look like me.
I can't tell it's you no matter what. What would you like to tell me, ma'am, about Mr. Majerus?
To be candid, Your Honor, Ms. Majerus has another case that we're representing, well, actually 2 cases. But he's been a great client, has a job here and has been working here and is local to here. So would ask for the lowest bond possible, Your Honor.
Oh, yeah, tremendous client. Repeat business all the time.
Yep.
And blows a 253. I don't know what, Ms. Peskin, I know you're a good attorney. I don't know what you're going to do with that one.
I'm sure we'll do something
Deputy.
great with it, Judge.
Yeah, I'm sure you will. Deputy. Is he out on bond?
Yes, sir. He's on 2, one for domestic second and unarmed burglary. He has California and Arizona history.
Case numbers, ma'am?
Both are 24. 0144 0190.
All right, Mr. Majerus, on the driving under the influence, bonds 2,500, no alcohol. Court date's going to be May 15th at 8:30. I'm revoking and releasing 24, 144, and 190. Good luck, sir.
Step
Thank
to
you,
your
Your Honor.
right to the T. When the green light comes on, son, it means you can't get out. He held you without bond. State your name, sir.
So, Mr. Seagroves?
Yes, sir.
So you're for the court charge of possession less than 20 grams of marijuana, possession of paraphernalia, and resisting officer without violence. Do you understand those charges?
Yes, sir.
All right, sir. I understand you've been given copies of paperwork advised of your rights.
Yes,
Mr. Attorney, please move. You've indicated you're going to hire your own attorney to represent yourself. Is that how you're going to proceed?
Sorry?
You're going to hire your own attorney or represent yourself?
I don't know. I've never been in trouble like this. I don't, whatever y'all tell me to do, Your Honor.
Okay. Deputy, criminal history?
So the Georgia, well, he has some sentences here last year for delivery, possession of altered firearm, carrying and concealed, and a FTA. Georgia, there's a DUI in 21 with 3 FTAs in 22.
Okay. Bonds 2,500 on the pot, 1,000 on paraphernalia, and 2,500 on the resisting. Court date's going to be May 15th at 8:30. Good luck, sir.
Step to your right to the T. When the green light comes on, sign next. Red X, ma'am.
Stand here.
State your name.
Michelle Templar.
Simple, you're for the court charge of driving under the influence. You understand that charge?
Yes.
I understand you've been given copies of paperwork and advised of your rights. Is that true, ma'am?
Yes.
Based on your application?
I want to see what they see, because they're in jail, right? Is it just a screen in front of them? Because generally they always look confused when they first walk in. They do, and I really want to see from their point of view what they see without going to jail. Legal fiction. Thank you so much for the turtle fund. Yeah, that may have accidentally just became a thing. The turtle fund. Thank you so much, legal fiction. I appreciate it.
I find that you do qualify. I'm going to go ahead and appoint the public defender to represent you, so you have an attorney now. Any questions about that?
No, sir.
Deputy, criminal history?
Have a DUI, battery on a Leo, and a resisting with an 18 with a BOP and 19.
Allie, how about you go cry me down there, and I will watch your appearance on Judge Van's daily docket. How about that? How about that? I do not want to get arrested in Florida. Absolutely not. If I get arrested in Florida, it's gonna be a story. Like I'm gonna make it a story. Try to make the most outlandish thing. You know, like the guy. One of my favorites is the guy who tried to sue somebody for selling him an invisibility cloak when he thought he was invisible trying to rob a bank. That's one of my favorites. But have you guys ever done the Florida Man challenge? Florida Man challenge is awesome. Type in Florida Man and then your birthday in Google and read the very first headline that you see. You got to read the first one. You can't skim for a good one. You have to read the first one. That's the rule of the game. But you know what? Let's do that right now. Let's check mine. See if it's changed. Florida Man 327. All right, here we go. What's mine? Florida man hit mother, stuffed dumplings in her mouth for refusing to dress as mannequin. Oh, yeah. Yep. You guys are going to have a tough time beating that one. Florida man hit mother, stuffed dumplings in her mouth for refusing to dress as mannequin. There we go. All right, let's keep going.
Bonds 2,500, no alcohol. Court date's going to be May 15th at 8:30. Good luck, ma'am.
Step to your right to the T.
All right, I'll check yours. But that's not how it works. You're supposed to check your own and let me know what it says. But all right, so what did it say? Would you say 1104? 1104. All right. Oh, this is a good one. Florida man accused of driving around naked with electronic device attached to what? Oh, his face looks bad. I don't know what he did. I don't want to read it out loud, but he looks like he got beat up. He's got stitches on his eyebrow, his nose, down his face, 2 black eyes. Florida man accused of driving around naked with electronic device attached to what? Is what your headline is. Yeah, I think you actually beat mine. All right, let's go. I'm only gonna play this for like 10 more minutes, and then we're gonna peace out for the night. Like I said, I didn't have any intention on making I haven't gone through and edit this yet, is what I'm saying. So generally, I'll piece together, the funny parts, is Judge Van's funny little quips that he does. But yeah, all right, let's go.
When the green light comes on, sign next. I am. State your name.
Sorry, for the court charge of driving under the influence. You understand the charge, ma'am?
Yeah, I didn't play it. I didn't release it this morning. I've had kind of a meh last 2 days, and I've been kind of lazy. I think I have 3 bonus clips that I haven't released that I've played over the last week. So they're going to come out this weekend. While court's slow, I'll play the bonus clips that I play. But yeah, I didn't release it. But thank you for checking. I appreciate you checking.
I understand you've been given copies of paperwork, advised of your rights.
Yes, Your Honor.
Based on your application, you make too much money to qualify for a public defender. So the law recognizes your financial situation may change, and you can reapply for a public defender if you need to. Otherwise, you have to hire your own attorney or represent yourself. Any question about that?
No, Your Honor.
Deputy, criminal history.
Inside of West Virginia, 15 was a DUI, 20 fraudulent schemes times 2 embezzlement and forgery and conspiracy.
Onset at 5,000, no alcohol. Court date will be May 15th at 8:30. Good luck, ma'am.
Thank you.
Step to your right to the T. When the light comes on, sign next.
That dude, that Florida man has played way too much Red Dead Redemption. Just walking into homes trying to fist fight everybody. All right. Yeah, let's finish this up.
Next. Wait for the light to come on, ma'am. Red X, state your name.
Ms. Bennett, for the court, charge of driving license, driving under the influence. You understand the charge?
Yes, sir.
I understand you've been given copies of paperwork and advised of your rights. Is that true?
Yes, sir.
Based on your application, finds you do qualify for the services of the public defender's office. I'm going to go ahead and appoint the public defender to represent you. Any question about that?
No, sir.
Yes, criminal history.
Shows no history.
Pre-trial release, need to be at the pre-trial release office first thing tomorrow morning. Court date's going to be May 15th at 8:30.
Mac, I do not believe you. I think you just made that up. But, you know, I'm going to say I do believe that, because if you did make that up, I'm going to applaud you for your your imagination and storytelling ability, because that's hilarious. All right, I'm going to play this for about 4 more minutes, and then we're going to cut out. So 1 or 2 more defendants, and then we're out. I hope you guys all have a great night. Let's jump into Discord afterwards. You know, we can talk about, you know, turtles and stuff, I guess. But yeah, I got it set up to raid KCC, so you know, we can jump over there and continue the night. I'm gonna be over there. I'm gonna say hi. I'm gonna hang out for a little bit. Then I'm gonna jump in Discord. Hope you guys have a great night and take care. Don't do anything dumb. You know, it is Friday, and yeah, if you do something stupid, I will cover your case. I will, and I'll be jumping up and down saying, "I know him. I know him." So just so you're aware. All right, let's go, and yeah, that's all I got. Until next time, bye.
Alcohol.
Step to your right to the T. When the green light comes on, sign for your copy of it. Next. Red X, ma'am. State your name.
This guy's before the court charge of possession of heroin, possession of fentanyl. You understand the charges? I understand you copied paperwork and advised of your rights. Is that true, ma'am?
Yes.
Based on your application, to qualify, I'm going to go ahead and appoint the public defender to represent you. Any question about that? Deputy, criminal history.
I actually have this as an added charge, but the history doesn't tell me what she's already in custody on. 22 controlled substance paraphernalia, domestic felony, and 21 cocaine possession paraphernalia, 19 domestic criminal mischief, VOP, resisting 2 controlled substances and a paraphernalia. It goes back to 98 locally.
Onset at 15,000 heroin, 15,000 the fentanyl. Court date's going to be May 30th at 9 o'clock, 3 NWAs. Good luck, ma'am.
Step to your right to the T.
All right, time stamping it. 11 minutes. Okay, 11 minutes. So the next time I do random Judge Van, 11 minutes. We got to remember that. Okay, I'm gonna play my outro, and we're out. We're peacing out. Let's go hang out with KCC for a minute. Let's jump in Discord. You can do whatever you want to do. But have a good weekend. Don't do anything dumb. Until next time. Bye.